President, on behalf of the defendant, is Attorney Tammy W. Salins. The court had a brief discussion off the record with counsel and with plaintiff regarding the status of this matter. And how I'd like to start it is, Ms. Salins, relative to the 529 plan regarding education, what is your client's position regarding the 529 plan?
My client has no objection to Jolene and Maxwell's 529 expenses being paid by both parties pursuant to the terms of the settlement agreement until the money is gone. And instead of calling it college expenses, I would just call it higher education 529 expenses, because the IRS determines what a 529 expense is, not my client or I. But we will call it higher education instead of college. So that would incorporate a master's or a PhD program until the money's gone.
So your client's position is they just simply submit their expenses to the
Raymond James
and until the money is gone, they will be paid.
Yes, and that's the way it was set up. And the plaintiff was informed of that. If she had any questions, she could contact Laura Killinger at Raymond James,
okay,
who facilitated this.
Your Honor,
yes.
I was not contacted by anyone regarding this plan. No contact by anyone. I have no knowledge whatsoever of what she just said.
Well, it's on the record now, and it sounds like it would satisfy you, right?
It does.
Now, regarding this tax issue that you're referencing, I'm not sure about that, number one. And number two, it wasn't noticed up today, but regarding a 1099 with one of the children, do you have any other comment on that, Ms. Eisler, before I go to Ms. Salins? Because it's not before the court, but.
Well, I'm just concerned that because the check was held, Mr. Eisler had the check in his possession since August and would refuse to turn it over. So that is how this whole process got started.
Okay.
So I'm concerned that for 2023, there was a check issued to Jolene Eisler, but never given to her. Now, this is a new tax year, so I would like someone to check into that, meaning Mr. Eisler, with his accountant.
That would be between the recipient and her mother, but the recipient is Jolene. And if Jolene has questions regarding what the ramifications are, but if she didn't receive 529 funds, then she would not receive 1099 for those funds. It seems logical to me. Why would she get a 1099 if she didn't receive the money? But if the plaintiff has concerns, then the plaintiff is clearly able to consult with her CPA regarding her concerns. That has nothing to do with my client.
Well, for me, it would seem to me that Ms. Eisler is looking at just streamlining this so that the parties can vote their separate. That's what I'm getting from it. And Ms. Eisler, regarding the tax issue, if the child did not receive any check, there's no income to receive, hence no 1099 or tax reporting. Now, if that check comes this year, that would go on the 24 taxes. I'm just guessing, but that would seem to make sense to me. I would suggest, since it's not before the court, get with your tax preparer as well. You can get those questions answered. If there is a problem, you can file the appropriate motion if need be. But regardless of it, it sounds like Mr. Eisler does not have an issue anymore going further regarding these 529 plans. It's been stated right on the record. So I think it's very, very clear and clarified. But if there's an issue, you can bring it before the court. But otherwise, the 529 plan, I think, is very clear now. You're both free to go. Thank you. Off the record. This is Ms. Salins' motion regarding custody, parenting time, and communication. She is present in the courtroom. She's in pro se. Mr. Curtis is present in the courtroom, represented by Attorney William E. Langeman. For both parties, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hands down. Before we go to Ms. Lenka from the front of the court office, as I understand it, the parties have joint legal, joint physical custody, week on, week off.
Yes, sir.
Miss, what are you requesting?
I don't even know where to start. I guess part of me wants to, I know it's like you should have a decision when you come in here, but I'm conflicted myself. My daughter loves her dad and I don't want to take her away from him and I don't want to request to have her taken away from him, but I need him to be a better parent, more active parent, of putting her first kind of parent for me to feel comfortable with it, because I feel like she's been really neglected on his part. And it's hurting her, and the arguing between me and him, it's very repetitive. It's not good for her. So because of everything, our prior hearing, I had requested that she be with me in the night before school due to her not making it on time to school. Do you recall?
Yes.
Okay. Well, she didn't make it again to school. He had taken her to the doctors. I think I supplied the courts with the paperwork because I pulled it up on my chart. There was nothing wrong with her, but I let it go. When she came back to my house, she said, "Mom, I need to tell you something."
Your Honor, I'm gonna have to object at this point in time. I'm sorry, but anything the child says is gonna be hearsay, and I don't think that's.
would agree. Objection.
That part has completely gone then. I don't know what to say anymore because I didn't bring an attorney and I'm just trying to do what's best for my kid.
Are you requesting an adjournment to get an attorney?
No, because time can't wait. Part of my request had to be added because I'm sorry, I don't need to cry. I'm very frustrated.
You're fine, go ahead. When you're ready.
She broke her clavicle. She fell in gym and she tripped playing tag and she hit the wall and she broke her clavicle. So she had to go see Dr. McMahon. And he said that she needed 4 to 6 weeks of wearing the sling. She'll be 10 on the 23rd of this month. I had tried to communicate with front of the court with Mitch and Mr. Holbrook, I'm sorry. She didn't want her dad getting her undressed and dressing her, and she can't lift her arm. So we had tried to come up with a stipulation. I'm really upset and sorry.
Okay. We're talking about family.
I'm just trying really hard to do what's best, and I feel like it's really, really hard.
How many more weeks does she have left of this bathing?
Her appointment for her follow-up is on the 27th at 3:45. Yes. So I was trying to give him time still, so we had come up with a stipulation that needed to be agreed on by both parties. I had told Mr. Holbeck that I couldn't do 2 days during that time, that I needed him to pick one day, and initially we had agreed on a Wednesday. He was gonna take her to get something to eat and then drop her back off at 6:30. That would give him some time with her, but she's not comfortable having her dad shower her and get her dressed.
And how old is the child?
She'll be 10 this month.
Okay. So what I need to know is, what is the proper cause or change in circumstance warranting potentially a modification of custody? Because that's what you're asking for.
Yeah.
Is this just a temporary thing while she is, lack of a better phrase, laid up, or is this something you're looking?
Initially, it was to request a change in custody due to her being absent yet again. It was considered an absence because it was so late. She had went to the hospital for a stomach ache, but I had provided the courts with documentation of location times and how long she sat on the side of the road, and he said that he had to rush her to the hospital. So he took her into the ER in McLaren, but all of a sudden at 10 o'clock, she was perfectly fine and able to attend school. Later, after school ended, we ended up taking her to the city, which is provided by location. I have a tracker on her phone, all the way to the city to go out to eat and stuff. But if she was so sick, I can tell you what she told me, but apparently that doesn't hold in court.
It's
So,
hearsay. It is under the rules of evidence.
there's nothing more that I can do except, I know she wasn't really sick. She wasn't. If she was sick, why would you rush her into the ER 2 hours after I take her to school? You're sitting on the side of the road for how long? And I'm terrified that something's wrong with my kid. That's why they're sitting on the side of the road for so long. Like, is he unable to get her back in the vehicle? Is she puking outside the vehicle? So I call and she tells me whatever, and I can't say it because you can't say it in court. Then he turns off her phone, so I can't talk to her. Then he tells me she can't have her phone while she's at my house. You can't talk to her on that phone. You might as well keep it at your house. And then we end up discussing that whole issue. So then it goes to turning off the location on her device. So I can't see where she's at. So I'm not supposed to know if she gets to school on time or not. She was absent yet again. But if the courts don't want to issue it because they see that there's medical documentation provided, then I'm requesting.
How many times has she been absent since the last year?
Once on his part, I had to pick her up early the day that she broke the clavicle. Yeah, and that should be it because I scheduled all of her follow-ups after school.
But you're saying he did take the child, but you're questioning how he took the child.
I'm questioning why she sat on the road for so long if she was so sick, and then I'm questioning you take her into the ER and all of a sudden she's better at 10 o'clock and can attend school.
Did she go to school that day?
Yeah.
Anything else?
If the courts don't agree with modifying that, my request, I request that they take into consideration at least until the 27th, that he can have some visitation time, but she doesn't want her dad to undress her, shower her, dress her back up, and at the age of 10, I completely understand.
Is there a way, are you able to communicate with Mr. Curtis?
We had
With each other?
communication issues through app close. Actually, Mr. Holbrook was perfect. He could probably fill you in more than I can.
Well, I'm just asking whether or not you can just have a sit down and talk with Mr. Curtis when it comes to your child.
I would like to.
Okay, well, this is what I'm thinking. What about up until the 27th? That if the time continues, when it's time for bath time, you come over to the house. Okay, you already shook your head no.
I have several children, and
Oh, I don't know that. This is what I have. This is all I have. I don't go stalk people on Facebook and all that stuff. I don't have time for that. I just have what's in this file. So,
Your Honor, I have LPN classes. I work. I have a 4-month-old baby. I have a 3-year-old baby, and then there's my fiance has 4 other children. I can't take off and leave everything behind to go drive from Pigeon to Bad X to give her a shower to then come back home.
but if you're proposing though, that you'd have the child throughout the week, how would you be able to take care of the child if you have all these other activities?
Because she's at home. That's an hour of drive time. That's an hour that
Watching the child if you're working or having classes.
she's in school during the time that I work. I am out in time that the bus gets home and I meet him at the bus stop. And then when I have classes, she is with my fiance's mom and my fiance.
Oh, now I see. Okay.
I have one night class as of right now that ends at 7:55 and it's in Midland. I have to come drive back home, but the other classes are online for the time being.
Okay. Your responses.
Your Honor,
Either one is fine.
so first of all, there was 2 motions filed here. Regarding the motion to custody, I'm sure Your Honor had an opportunity to read my brief. I've heard you cite the law already previously today. The actual document that refutes the defendant's motion for change of custody is actually, she supplied it in her information. The child complained of abdominal pain. They took the child to the doctor. The doctor determined that she was constipated. The child was relieved. The child went to school. I don't believe that, constipation is a significant proper cause, I think that would fall under the normal life, things that happen in life. This court previously ordered that if the child is not available, then there needs to be a doctor note. Nobody's complaining that they took the child to the hospital for a broken clavicle, and then the next day was able to go to school. That happens. The child's able to go to school after constipation was relieved. That happens. He wasn't sure. He's not a doctor. She's not a doctor. The fact that he took the child to the hospital to have to make sure everything was okay. It's my understanding she'd been complaining for several days about abdominal pain. And so she had been not having bowel movements for several days, and they fixed the problem. So he wasn't sure what was going on. He might have been worried it was an appendix or whatever it might be, and he took the proper care to do so. After school, if he decided to take the child out to a restaurant, he has that ability to do so. I don't believe, if we assume everything that this defendant filed in the motion for the change of custody, everything that she supplied was even true, I don't see how we could even order a change of custody, even if we assume that to be true. It doesn't rise to that Bob Barker level. Therefore, I'd ask for that motion to be dismissed. Now, regarding the motion for parenting time, that's a little tricky situation. The injury to the arm or the shoulder of the child was on February 15th. That was my client's parenting time. Okay. Parenting time is on the 16th, I believe. They exchange on Fridays instead of Sundays. So he agreed. So she took the child that night. He allowed her to do so. He agreed. Actually, my understanding is Ms. Lemke contacted Mr. Holdwick about trying to work something out regarding this, and I think she mentioned it in her motion for parenting time. They were not able to come to an agreement that was written. However, the idea that he requested 2 afternoons with his child and was willing to give up a week of parenting time does not seem unreasonable. And in fact, that's what they did. On Tuesday and Thursday of his week of parenting time, the only time he had was a Tuesday after school until 6 and a Thursday after school until 6, is my understanding. Now, the proposal by Ms. Lemke was, after she had the child for 2 weeks straight, Mr. Curtis was going to get the child for 2 weeks straight to make up. And that on her normal week of parenting time, she would have 2 afternoons of parenting time to make everything equal. That seemed very reasonable. That's what they did, except for when he went to go exercise his parenting time, his 2 weeks, which was actually one of her weeks, she denied him parenting time. And now she files a motion saying that it will be another 4 to 6 weeks. He has not seen the child now for 3 weeks, except for those 2 afternoons. And so, furthermore, in this motion, she attached a slip from the doctor regarding the young child's clavicle. Mr. Curtis was at that doctor's appointment. Okay, and it's his understanding that this child is not in a cast, Your Honor. She is in a sling. According to the doctor, there was no restriction taken. The doctor the child has the ability to undress herself and to shower by herself and to get dressed by herself.
Do you have documentation of that?
Excuse me, just a moment. There's no, nothing that says that she can't do that. She is not in a cast. And so he was there, he was present, he was when that was made. It's his understanding that parenting time he should get an extra week of parenting time to make up for the week he lost. And they should move forward with parenting time at this point in time on a week-to-week schedule after he gets his 1 week of makeup parenting time. Now, it's my understanding that this was not done in writing. And that's unfortunate. Okay, that
was my next question.
And it's not, but it's my understanding that the parties can agree to a parenting time order. And it doesn't have to be in writing. It's usually it says as the parties agree. Now it's much better if it's in writing. And if this is the game that the defendant wants to play, they have 8 more years of parenting time. All right, and he agreed to it on her request. And he exercised, he allowed her to have the child. He took the child for 2. He's willing to give the child, her the same thing that he had. And if she wants to play that game and say, oh, it's not right and I can't enforce it, we understand. I've advised him of that. But at some point in time over the next 8 years, she's going to want an accommodation. Something's going to come up. And this does not bode well for trust because it was her request to do this 2 weeks on, 2 weeks off. And he agreed because he thought that, you know, she was just injured. He's like, okay, fine, I understand. You know, at that time, she just broke her clavicle. Go ahead, let's do that. That's fair. I'm willing to work with you. And if she wants to go back on that agreement and argue, oh, it's not in writing, fine. But if you live by the sword, then you die by the sword.
With writing was that the doctor said that the child can bathe herself.
That is not in writing, but there's nothing in writing saying the opposite. So, I mean, I guess that's, you know, she's supplied no evidence to suggest that the child cannot do that. The only thing that it says is that it says no gym or recess activities. That's what's been supplied to this court. That is the extent of it. There's an opportunity for limitations and restrictions. She submitted this. There's nothing in there. Needs help bathing, needs help dressing. There's nothing in there. So if that was something that was ordered by the doctor, it should have been in there. And it's not there. And so it is our position that she cannot do gym. She cannot do recess. She can dress herself, she can bathe herself, she can go to school, she's able to take notes, she's able to complete all these things. You know, out of all the things, she can ride a bus to and from school where she might get jostled, but she can't dress or bathe. How is she going to the bathroom and doing these things at school? I mean, I think.
What are you asking for?
So I'm asking for both motions to be dismissed and 1 week of parenting time per the agreement. Make that parenting time for him, and then they go back to this week on, week off schedule. And I understand that it's not written, and that's fine. And I just, you know, and obviously she's on notice that if that's the way it's going to go, it's going to be hard. Now, it's also my understanding that they've been communicating outside of app close, which is against the rules. However, both parties have made a legitimate effort to use app close. All right. I believe Mr. Holikin talked about that. We came in earlier today. We still have not been able to resolve. We probably spent half an hour to 45 minutes to try to get app close resolved between the two of them, and we've still been unsuccessful.
What's the status of that?
There actually is a notice of hearing regarding communication for today from the court filed regarding this issue. I had met with the parties and had their cell phones, app close was deleted, reinstalled, invite sent. Before we came into the courtroom, the understanding is that after court today, the parties were going to establish a new email address for each of them and try it again with the email address to see if that will help. If that does not help, they both had the understanding then that a stipulation could be done that the standard communications remain in their order, but that app close for communication purposes be removed as they've been having difficulties. The parties can go months, if not years, with good communication in and out of app close, and we don't hear a word. But then it's almost as if a bomb goes off, and this just blows up when we have an issue. So they haven't shown that they have an ability to co-parent and communicate. But when things get difficult, there's just no communication. And that's part of the issue, as was stated. Yes, this Lemke did contact our office. We did reach out to Mr. Curtis regarding this agreement to switch weeks with the child's injury. Mr. Curtis had proposed the 2 week or the 2 evening visits. We had a hard time reaching Ms. Lemke due to her work schedule. We had sent an email to both of them saying, this is a proposal of the agreement. Please respond with the acknowledgement or agreement. Her response was, I don't agree to 2, maybe 1. And when it was sent to Mr. Curtis of that proposal of not agreeing to 2, but 1 evening visit, I didn't get a response until later, and when our office had contacted them, there still was no agreement signed. So there was no order to switch, but that was the original understanding. They were in the process of working, and when that was conducted, it was late afternoon on a Friday that began Mr. Curtis's time for that.
Ms. Lemke, do you have anything else you want to present?
Yes, she can't shower herself. She can't get herself undressed. She can't get herself dressed. We went and bought her a bunch of sweatpants that she's been wearing to school. She wore jeans one day, but they had to be snap ones because she can't do it herself. She has a writing assistant at school that helps her write in her planner and helps her write out different things because it's her right arm that's the difficulty on, and she's right-handed. There's a whole bunch of stuff that's difficult that she can't do. I have to tie her shoes for her because she doesn't want to move her arm away. And she doesn't feel comfortable having someone that's a male. It doesn't matter that it's her dad. It just matters that it's a guy.
Well, why are those restrictions listed in the doctor's prescription?
I don't understand. I don't know. I only provide what I have, and I've just been going with what I have. I understand it probably would have been better if the courts would have seen something like that, but in real life, at home, she can't do a lot. I'm helping her shower. I'm helping her get dressed. I have to dress the weak side of her arm and then put it over her head and then put the other side in. To undress her, I have to undress the good side and pull it over her head and undress the weak side after that because she can't move it up. It hurts. Sometimes she goes to the office at school. They call me. When she has pain, they give her Tylenol. It still hurts her. She's still limited to a bunch of things she can do. My fiance's son carries her backpack on and off the bus because it's too much for her to do. She can't wear her coat the right way, so we have to zip up her coat every day, and she can't put her arm through the sleeve of it.
If you're not home to take care of the child, who takes care of the child?
When would I not be home to take care of the child?
Well, I thought you said you have sometimes evening appointments and other matters.
She comes with me on everything except school.
Okay.
I take my children everywhere with me.
Okay. Mr. Langeman, is there anyone in your client's home, female, that can help with dressing and undressing if that's the issue?
His sister's available, is his understanding, if that's this court's desire.
I have spoke with my daughter about that, and she stated that she feels uncomfortable because I gave her different options. I asked about different people that are females in his family, and she said she did not want that. She doesn't feel comfortable, and she said, Mom, I'm sorry, this is what the child is saying.
I understand that,
Never
but she's
mind.
not able to.
Can't say that part. Hold on.
Go ahead, Counsel.
So, one more thing she brought up in her motion that I would like to address is my understanding is that parties have discussed it with Mr. Holbrook as well as telephone parenting time, when the other parent has the child. She brought it up.
Can you address the court then, sir?
Oh, I'm sorry. So
Go ahead. Well, actually, I guess I need to hear from her first. This is part of her motion regarding communication.
she addressed it, I thought. Okay.
You want to have the phone contact? What's going on with this?
Your Honor, if I can on that one.
Yes, go ahead.
So their original judgment of the board states that when the child is in custody of one parent, the other parent has the right to contact the child by reasonable telephone access, text messages, electronic messaging, included but not limited to email, providing the child has proper access to receive such communication. My understanding is that the minor child has her own phone, so the parties can contact the child directly for that talk time.
I also heard the dad's turning off.
Correct. I've heard both sides. I've heard that. I've heard that the child's been grounded from the phone, so when dad tries to contact, she can't have her phone, so she's got to call her mom, which there's been issues with the communication issues between the parties. Talking to counsel and then Ms. Lemke also this morning, it kind of sounds like there would not necessarily be an objection to that provision being modified to state a certain days and times that they cannot agree on talk time. I discussed with Ms. Lemke briefly that, if the child's with her and the child's grounded and can't have her phone, that it's dad's talk time, that phone be accessible for the child to talk to dad. And then as soon as the conversation's over with, yep, all right, I'm taking it because you're grounded from your phone.
Right.
She didn't object to that. She understood, so I feel maybe some clarification on that could alleviate some of the issues.
So just set up a schedule in the event parties cannot agree.
Correct. Yep, and the child has her own phone, so I mean, really, it's just the parents contacting the child.
Any comment? Go ahead. Now I know where we're at.
I'm in agreement with everything that was just stated, Your Honor.
Do we have dates and times we can have the phone communication in the event that parties cannot agree? Is there a proposal?
I would ask for 7 o'clock in the evening. That puts them shortly after dinner. And, you know, she's 10, so I don't think it's too late at night. So that would be my recommendation, Your Honor.
How many days a week?
We would ask for 3 days a week. That's, you know, about half the time that.
Is there an order for this?
The order does not have specified times, Your Honor.
Okay.
We have typically done Tuesdays, Thursdays at 7 o'clock. Michelle said possibly Sunday, Tuesday, and Thursday since they exchange on Fridays. And again, if they cannot agree on any other times, I do know Ms. Lumpia has contacted our office numerous times regarding routine with the child. I believe part of when we were trying to negotiate a stipulation prior to court with the switching of the weeks, she had stated 6:30 was, I think she states that the children start to be ready for bed. So I can let Ms. Lumpia kind of elaborate on that. So not sure on the days, but times, I believe 7 o'clock, there will be the objection as stated to our office from Ms. Lumpia previously.
Is that too late?
But our kids have a specific routine.
Okay. What about 6:30?
I mean, 6:30 is the prime time because that's when we start reading books and going through planners and brushing teeth and showering and all that stuff.
What about 6 o'clock?
That's fine.
I agree.
6 p.m. And Sunday, Tuesday, and Thursday. What are your thoughts on that?
That's fine.
Does that work for you, Mr.
Yes, I agree.
Okay, so ordered. That is if the parties cannot mutually agree on any other time. Okay, so that's the communication part, but without going into what the child said, but what is the issue with Mr. Curtis's sister providing the assistance? Other than the child saying she doesn't want it.
I have told her for years to keep her body private, and that is her understanding.
This would be her aunt.
Correct. I believe it is the child's understanding that she should always keep her body covered no matter what. I'm currently the only person that's allowed to do it.
Any other comments?
Just very quickly, Your Honor, it's my understanding that the aunt has a very close relationship with the child, and at some point in time during the child's life was actually functioning as a foster parent of this child, is my understanding.
What is the answer?
Jessica, and obviously her main, is Curtis. Sure, yeah. But yeah, so this person functioned as a foster parent to the child. She has a very close relationship with the child. The idea that she would not be able to, bathe and dress when she actually functioned as a parent bathing and dressing her in the past, I think is not reasonable.
She was like 2. She was 2, or as you know, a 2-year-old doesn't really have a whole lot to object to as far as privacy because they have no understanding of privacy at the age of 2.
I'm ready to make my ruling. There's a motion regarding custody and parenting time filed by mother in this case. Parties have joint legal, joint physical custody. They have week-on-week custodial time. And the issue before the court is whether or not that should be changed, whether there's proper cause or a change in circumstance. The child suffered not too long ago a debilitating injury at school. As a result, she is under some restrictions. Some of the restrictions alluded to by the plaintiff in this, the defendant in this case, are not listed in the discharge documentation. However, I'm not doubting what's going on here. It's just a matter of the child getting through an injury. The other issue before the court is missed school. At our last hearing, the court made it abundantly clear that the child is to be in school. Dad needs to get the child to school on time, and if the child's not on school on time, there must be a doctor's slip. He complied with the terms and conditions of the new order. There's no question about that. Now, the idea of sitting there for a while and or going to Bay City or Saginaw or wherever they went, it was on his time, but the bottom line is he followed the court order. I don't find proper cause or change in circumstance in this case, so the motion regarding that is respectfully denied. The original orders will continue in this case. So whoever's time it is right now, the child is supposed to be with that parent. Relative to the issue of taking care of the child while on dad's time, the court will require that Jessica Pretty be the individual that provides the bathing and services for the child. That will alleviate the concern that mother has or the child may have relative to that. The parties are to communicate via that close communication. In the event that that fails, they need to notify the friend of the court to set up an alternative arrangement. Also, the court has previously ordered that talk time on the non-parent's time, or the parent that doesn't have the child during that time frame, can communicate Sundays, Tuesdays, and Thursdays at 7 unless the parties, I'm sorry, 6 o'clock unless the parties agree otherwise. And anything I'm missing, Mr. Holbrook? That'll be all.
Would you like me to prepare an order or is?
I would.
Thank you, Your Honor.
I'd ask, just parties can kind of sit tight if they want to be on other sides of the holiday, fine, to establish the email so we can get, we'll take care of the day.
Yeah. Mom, we need to get that email.
I would prefer to leave. Thank you.
Well, that's her decision. If she fails to do so, you can show us. Key, battle time and date set for friend of the court show cause regarding allegations pertaining to Ms. Babb. Both parties are present. Would you both please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
I do.
Thank you.
I met with the parties briefly January 25th of this year, Your Honor, regarding parenting time. Due to a complaint that our office had received, there was a ADR report that was provided to the courts from that meeting. There was a significant period of time that the minor child had not had parenting time with Mr. Henney, which was discussed in our office. He had filed a complaint for denied parenting time months after the last order entered and months after no parenting time had been occurring. But a brief discussion with the parties was that my understanding the child was not wanting to go. We had established that, I believe, beginning of February was a weekend that Mr. Henney would have his parenting time with the minor child. His court order weekend, she had a bunch of extracurriculars going on, so the parties agreed in our office to switch to the next weekend to be doing that. I did tell the parties that if we had received a denied parenting time complaint regarding that weekend, that I would set for a hearing. And that is what happened, Your Honor. We received a denied parenting time complaint from Mr. Henney that he did not get his parenting time with the minor child. And as a result, the show cause was scheduled or denied parenting.
Mr. Henney, do you have any idea why the parenting time wasn't held?
She just been basically telling me that my child just don't want to see him.
That's it, right? Response.
That is correct.
Child's 15.
She is.
What do you do to foster and encourage a positive relationship with the child and father?
I sit down with her whenever he texts me or communicates with me over app calls. when he has a message for her, I talk to her and let her know that she is 15 and she shouldn't, it's not that she can't not make her own decisions. She's a voice, she's opinion, and should be heard. She's almost an adult in 2.5 years, so be 18.
That's the problem. She's not an adult yet. You are to foster and encourage parent-child relationship with the other parent. And frankly speaking, no disrespect to any of the children out there, but court orders apply to the parents. And the children have to be with the other parent pursuant to court order.
I agree.
So what can you do to make sure that that's going to happen?
I can't. She refuses to go. And I do encourage that I am not withholding her from her dad. If she wants to go, she is more than willing. I don't want her to have regrets, but it's not like I can pull her out of the house by her hair and make her go.
Well, no, not necessarily that, but when you advise a child like that they have a choice, that's causing the problem.
When she feels unsafe in his care,
I'm not talking about safety. I'm talking about if you just express to a child, hey, honey, if you want to go to dad's, you can if you want to, but you don't have to. It's your choice. I mean, that's what is kind of being said.
That's not what's being said.
Okay, then what's being said?
She comes to me with her issues in regards to safety at his home. I don't say, yeah, you have a choice. She has a therapist. She has been diagnosed as autistic. She has a 504 plan at school. She sees her social worker. There is a broad spectrum of people involved in this that know about the issues pertaining to the situation.
Is the child able to speak with court privately about this?
Yes, I encourage it.
Dad, do you have any problem with that?
I have no problem with it.
Let's do that. Let's arrange a visit with the friend of the court, me and the child, and we'll reconvene on this matter whenever we can schedule it.
I don't know how late you would be scheduling these meetings.
What time does she finish school?
3:18,
Which school district?
Carol. I can see if she
4
has any.
o'clock? We do a 4 o'clock?
Absolutely, yes, Your Honor.
And then renotice this for what day?
We can either go the next day, the 15th, or March 22nd.
Which day would you rather have the hearing, 15th or 22nd for both? And you can appear via Zoom if you wish. I'll allow that in this situation.
As soon as possible, so the 15th.
15th work for you, sir?
I'll be in here next Friday as well, Your Honor.
Okay. And that's what we'll do. March 15th. I'm assuming you'll provide notice now?
Yes.
Okay, we'll provide you notice, and then you'll both be free to go. In the meantime, though, prior orders do remain in effect. If it's dad's time, mom, you are encouraged to encourage the child to go to dad.
Yes, Your Honor.
Okay. That'll be all. In just a few moments is an objection to the friend of the court recommendation by Mr. Miller. Mr. Miller's present. Ms. Armstrong is also present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Michelle, please.
Chairman, the front of the court office had received a request for a review of child support from Mr. Miller. We did conduct that review and issued a recommendation on February 5th of 2024. The state of Michigan guidelines provided that Mr. Miller's support be set in the amount of $651 per month, including $26 for medical. However, that amount does not meet the threshold for modification, and we therefore recommended that support remain set in the amount of $600 per month with an effective date of November 22nd, 2023, which was the date of this request. The question has to do with Mr. Miller's disability status. The application was prepared based on both disability benefits and potential self-employment earnings based on the
Okay. Mr. Miller, what would you like to say, sir?
Sir, it was pretty much what they went off was before before they were going off of my income off the military disability. And then they were charging me 40 hours a week at minimum wage also on top of that. All I'm
Is this
asking
a
is,
business venture or something?
what's,
Is this some sort of business venture you have or?
no. This is just to lower the child support because I can't afford it. And it's going off of 40 hours of minimum wage saying that I'm able and capable of working a full-time job. And then they're also taking my military benefits, which they should be only taking what I've made this year off my LLC of what I've made this year. Now, I haven't filed my taxes yet, but I've only made, I got most of my 1099s, but probably under $6,000 this year alone.
So you're getting 1099s because you're doing some sort of self-employment?
Self-employment, I work by myself.
What do you do?
I do construction. So I get subcontracted out
What
through,
type of construction?
just wood floors, drywall, do a little bit of framing, concrete
You're getting disability?
through the military.
Oh.
Yeah,
Oh, okay, PTSD.
yeah.
Got it. Okay, got it. Okay. Well,
And I've been doing this for 3 years.
but Ms. Schultz stated that she based this information on the information you provided her.
No, that's wrong information, so that's what I'm trying to tell you.
The friend of the court office did not receive copies of any 1099s, so we did look at potential imputed earnings for self-employment based on the type of work being done. I also looked at child support based on only the Veterans Administration disability benefit and reported prior earnings. So based on only the VA benefits, support would be set in the amount of $217 per month. Based on actual prior earnings, support would be set in the amount of $984 per month.
What prior, sorry.
So if there are 1099s which our office can review, we can certainly do that, but that information was not provided.
I have 1099s with me, sir.
Right now?
Yes, I can go get them. I don't know why I didn't bring them up here.
Well, this is not something that Ms. Schultz can just do right now, but Ms. Schultz, do you suggest that we look at the 1099s? You look at the 1099s and attempt another
Mr.
copy?
Miller wishes to submit that information to our office.
But-
I have no objection to the objection hearing being preserved. We can review the information and amend our recommendation as appropriate. I don't have any issue, but we weren't provided the information to review it.
And see, that's the problem, because I could just simply say, you know what? You had the opportunity, Mr. Miller, you didn't turn it over.
This hasn't happened to me before. I was talking to Mr. Mitchell and he said I was good to go on all this. Like, he's the one I've been talking to. I gave him what I made from my 1099s and everything. I told him.
But he's not the one that's going to be doing the calculation.
Okay,
And Your Honor, I do want to clarify, a verbal indication of those earnings is not sufficient.
It's not worth the paper it's
We have to
written
have
on.
the actual documents.
I have the actual documents.
Your objection is preserved. You have 1 week to get the documentation to Ms. Schultz's office. If you fail to do so, support will be 651.
Yes, sir.
600, I'm sorry, effective November 27th.
Would I be able to give that to her now? Before, at the outside, when we're done here?
You may take it to our reception desk, they'll make you a copy,
Okay,
and then they will forward that
Okay.
information.
Before we do that, though, Miss, do you have any comment at all?
I do.
Go ahead.
A couple things. Obviously, I do not want to see him go back to jail for our kid's sake. So I'm not here to try and take all his money from him. My issue is, I know he is a talented construction worker, and I don't understand why he cannot get more side jobs, like he's always done in the past. And I do believe he does do that sometimes and works for cash, and nobody would ever know about it. So I do have that problem. I just don't know if I always believe the story that he has no income. I hope he's being honest with me, but I just don't ever know.
He's under oath now, so
Right. And
let's see what he presents, but go ahead. I
Okay.
want to make sure you have an
Yeah.
opportunity.
And I just want, I hope he understands, like, kids are expensive.
I'm the one paying for everything for them right now, except for the couple days a month that, or he has them about 8 days a month. I pay for everything. So I'm not here to try and take his money, and it's for the kids. Everything he gives me goes towards them. He did state this morning that his VA benefits should be helping and paying for their college. If that is true and he could get me proof of that, I might be willing to work with him and take the child support expense down a little, because part of what because what he is helping me with, part of that is for the kids in the long term. I'm trying to help save up for college for them, or whatever they choose to do after high school. So if he can get me proof of that, that might be something I'd be willing to work with.
All right, let's preserve it. Get that information. You have 7 days to do it. Sounds like you did it today.
Yep.
And then we'll just need your notes.
We will either, what we would do is issue an amended recommendation, whatever that final determination is.
And then
And the parties would have an additional couple of days to.
That's how we'll do it.
Also, sorry, I just don't, like, cause I'm already behind and I'm trying to keep up and catch up, you know what I mean? But like, it's really hard for me to even I'm behind on my truck payment, behind on my cell phone. They shut my cell phone off already. I'm supposed to pay my parents money because I live with them right now and I haven't even been paying them money. It's like, so I just don't, I mean, what she's saying is doing other jobs for cash or whatever. I have done a few jobs for a couple $100. Like, I'm not denying
I
that,
wouldn't be saying that under oath.
but that's it. I have it written though, but I claim it. I got it with the
Okay.
at two.
All right.
Also, that's 1099. I also have to pay taxes on that,
Right.
on your own LLC. So even though I made $6,000 through my company, I didn't get $6,000. They're gonna take 37%.
That's why I did that documentation.
Right.
We'll see you in a couple of weeks.
Right. Thank you.
Thank you.
Mr. Parrish's motion regarding custody, parenting time, and other matters is present. Ms. Seaver is present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help God?
Yes. Thank you. Ms. Schultz, can you shed some light on this?
Ms. Cedro was last before the court on February 9th, 2024. Defendant did not appear at that hearing. At that time, the court had continued the parties having joint legal custody, modified physical custody to mother, and then granted father parenting time pursuant to the Huron County long distance parenting time policy, which does include 1 weekend per month during the school year and 8 weeks during the summer break from school, as well as alternate holidays. Previously, the parties had entered an interim order regarding custody, which also provided for joint legal, but has placed physical custody with Mr. Parrish. And that order was from February of 2020.
All right, so father had physical up until
February of 2024.
February.
Modified the order.
Right.
So almost
He did not appear.
just under 4 years, according to the information orders. And his pleadings do indicate that the minor child may have some special needs that the court should consider.
Harris, what's going on here?
Well, it all started off, I received a letter from the courtroom. I was on vacation when she filed her motion. And I received a text via text. Well, my wife received via text saying my mom won, which that doesn't matter.
Objection, Judge. I have evidence of the very first text message that was sent and that he was aware of court. And he was the first one who called our daughter to talk about child support when he got back from his vacation.
Okay, we'll address it in just a bit. Go ahead.
Well, we were on vacation and I've told my daughter's mother several times, if my daughter needs anything whatsoever, give me a list. I will take care of it. With technology nowadays, I can either buy it online or go to a Walmart or a Meijer for any physical or material needs. She is currently on my insurance, and the verbal agreement me and my daughter's mother had is as long as she stays on my insurance, she will not go after me for child support or anything like that, which we totally agree. It was a verbal agreement. Then I, via text from my daughter's mother.
I understand it's not worth the paper it's written on either.
Yeah, that's true. But it's just, this is what I was told and what I'm going through. I have no problem supporting my daughter. That is not an issue. I don't feel like I should have to pay support to her to supplement her income because she can't work, which I don't think it's a legal excuse.
So what is the proper cause or change in circumstance warranting the court to review custody in this case?
She was in my house. I don't believe that somebody under the age of being a teenager should have electronics or be on social media. I try and run somewhat of a stern house. You come home, you do your chores, homework, dinner, shower, bed, rinse and repeat. I never deny her calling her mother or talking to her mother, but she was doing inappropriate acts on the internet, which I don't believe is warranted for my daughter.
Okay.
And I don't believe that's warranted for somebody under the age of being a teenager to have stuff like that going out on the internet. So then I gave my daughter the option. Do you want to stay with me and your stepmother, or would you like to go live with your mom? And what happened is my daughter said, I want to see what it's like to be with my mom, to see how that life is. So I gave her her choice.
How old is the child?
11, sir.
And she chose mom.
Yes, sir.
Okay, so from 0 to 5. From 0 to 5, where was the child primarily?
With mom.
I'm sorry, I'm asking.
Oh, sorry.
She was with me for the time being until she took her from me and went to Georgia.
5 to 11. Who was she with primarily?
She was with me for 3 or 4 out of the 6 years.
And why did you give the child the option to live wherever she wanted?
She was going through a tough spot talking to her mother because she was supposed to leave for Mexico, and then plans changed, and my daughter found out about it, and she started becoming very depressed and very sad about it because her mother wasn't giving her the attention she wanted. So she thought she was never going to see her again. But now that the plans changed, my daughter's mother is, oh, you're such a beautiful woman, oh, beautiful little girl, you should come live with mommy, you know, mommy will take care of you. And she started giving her the attention that she always wanted now.
Hearsay.
It does come from the child, it's sustained, but what are you asking for, sir?
I just don't want to pay the child support, and I want my daughter to finish out the school year here or out here in Ubly and return to me during summertime where she belongs and she will have some structure.
Okay, so you don't want to pay child support.
Exactly.
That's number one.
And I do not want child support for my daughter's mother either.
Is there public assistance involved?
No, sir.
Not that I'm aware of.
So you don't want to pay support. Child remains with mom until the end of the school year?
Yes, sir.
And then I'm assuming the child will go to you?
Yes, sir.
Summer?
Yes, sir.
What about the fall for the school year?
The fall, I would re-enroll her into school by our house, which would probably be a Christian school, because I live in Grand Rapids, which is 3.5 hours away.
Okay, so what would mom get for any time with the child?
She can have her any other weekend. We can meet up an arrangement to where we can both meet halfway, since it's a long drive for both of us. And anytime she wants to see her, just let me know. We can always work on an agreement. We could be civil about it.
Was there a point in time the child was living with you for an extended period of time?
Yes.
What was the time frame?
That was from 2019 till 2023. And when she was younger too, Your Honor, I'm sorry.
Okay, but in 2023 is when you had the conversation with her about
going with her mother.
And then as a result, she did go to mom.
Yes.
Are there any special needs issues regarding this child?
No, sir.
Education going okay?
As far as I'm concerned, it was, yes, sir. I don't know now.
So the main reason you want to change custody is support, primarily support, right?
Well, and that, I'm really not concerned about that. My concern is I want the safety of my child to be with me.
Okay, what's the safety concern?
I'm just, at one point in time, my daughter came to me, CPS was called to my daughter's mother's house.
When was that?
That was in 2019. When she first came with me, and there's charts in there from our doctor, our primary care physician, to where she was malnutrition, underweight. and-
Objection, Judge. If you can look at that paper, it says they were caring for the flu. Also, I have emails of when she was 3 years old and our family doctor said she was anemic and her fluids or her levels will always be low.
Well, we're well beyond
Yeah,
being very young. I'm talking about this last one, but your objection is noted, but that was 2019. What about 2023 or 2024? Anything?
She had a scare at school. Or then she wrote, "Kill me" on a folder or something, and her teacher saw it. So immediately I had a phone call from the teacher of her classroom.
This is a local school district.
Yes, sir, Aberdeen Christians, or no, sorry. Not charter, I'm sorry.
Oh, it's a school district in your area.
Yes, sir.
Oh. Well, what about here? What's mom been doing?
I have no idea. I can't even talk to my daughter unless it's like she's on speaker or whatever the case might be. Like I could text her here and there, but I do not get a response unless she's under her mother's supervision.
and interjection again, sir. Clearly, in his statement, it says on the second pages that mother's conversation lasting 5 to 10 minutes long, typical conversations where mother was moving to the house in Mexico, building and marriage plans with boyfriend. Sounds like they listen in very well too.
That was told to us.
I hearsay.
Wait. I'm not losing control here, folks. So you have a safety concern.
Yes,
2019.
yes.
Okay, response.
Sir, he's basically saying that the CPS in Huron County was on me and they allowed me to take one child to the other side of the state and the other one to Mexico without any repercussions. That's simply not true. Me and my neighbor got into it. CPS was called. They came out just like any other case for 30 days, seeing that there was no reason to keep going. My house was never in filthy conditions, which I have pictures of from 2019 to the day right now where Zoe sleeps and puts her head at right now. It also says that I had a 2-hour visit with my daughter before I left to go to Mexico. Sir, this is a picture right here of me and her and our daughter and my husband right now at a pool. There's no way you can do the date on it for 2 hours. I have plenty of evidence to back up all of this. First of all, this regarding custody, there is no separate sheet of paper for cause of concerns. There's nothing about the best interest of the child. There's nothing that says what he's asking the courts for. On the next one where that says parenting time. Yeah, there's nothing here. I went through and I did all of my work. I motioned the courts exactly what they asked of me. I've done everything. When I was asked to come pick up my child with a day's notice, I was on my way. When I found out the reasons, I had never been told, sir. Not one time have I been told that my daughter that was in a hospital, that was getting an intervention from other people. Not one time was I told that not only on the 19th or 2019, did the stepmother, the girlfriend at the time, tell people in the waiting room, in the emergency room, that the child was brought from the east side of the state and just left. You don't leave a child and cut off $7,000 of back child support, get a piece of paper of temporary custody made up, and that's not just the mother that just drops the child off.
This, the alleged behaviors that are occurring here locally in the school district.
Nothing.
Are those being addressed?
What behaviors? There's no behavior, sir.
Well, I read something here.
If you go all the way to the back one, it says, right here, it says, facts, it says right here that the lady recommend vital risk factors. Family history of behaviors, every single.
This motion. You refer,
Which one, sir? Because if it's the custody, there is nothing attached to it.
this would be his letter, page 3. Get the third paragraph down.
Mm-hmm.
I'm not going to read the whole thing. She was concerned with the fact that Zoe had written the words blank on her folder. You see that?
And I never got one phone call.
Okay, now where is that alleged to have occurred?
In Grand Rapids.
Okay, not here.
No, sir.
Okay. All right. You have your rebuttal argument. Is there anything else you have?
I'm just concerned for my daughter. That's it. And I just want to make sure she's safe and she's well taken care of.
Okay. Well, the court has to find either proper cause or a change in circumstance. What is being referred to by father in this case occurred back in 2019. I don't find anything recent regarding proper cause or change in circumstance. The motion is respectfully denied. Mr. Apley's motion regarding custody, parenting time, and other matters, he is in the courtroom. He's in pro se. Ms. Glass appears in the courtroom via Zoom. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Ms. Glass, will you raise your right hand? Did you hear the oath?
Yes, I did.
And you promise to tell the truth?
Yes.
Okay, thank you. Ms. Schultz, what's the current custodial rate?
Your Honor, on November 29th of 2022, an order entered granting the parties joint legal and joint physical custody with equal custodial time on a week-to-week basis year-round, as well as alternate holidays pursuant to the 2016 Friend of the Court Parenting Time Guidelines. Ms. Glaza was to exercise her overnight visitation at the home of her parents in Elwood, Michigan.
Thank you. Mr. Apley, what is your motion? What are you asking for?
Full custody or at least temporary custody of our child. Based on she got based on her history but she just was arrested with my child.
The child was in the vehicle?
The child was in the vehicle, yes, while she got arrested and caught with drugs. I don't know if you want me to elaborate on anything more, but
What alleged controlled substances are being thrown out there?
I believe meth and cocaine, crack cocaine.
Ms. Glaza, I have to caution you. Obviously, there are pending criminal charges out there, so I'm going to remind you, you have the right to, relative to any criminal allegations, you have the right to remain silent. Your silence cannot be used against you. However, if you do testify in this matter, you're under oath, and whatever you state in this courtroom can be used potentially in your criminal proceeding. Do you understand that?
Yes.
Okay. How do you respond to this at this time?
I have not yet been found guilty of anything, Your Honor.
Okay.
And I know what I've done wrong, and I'm taking the blame for that. But I have not been found guilty in a court of law. And I don't believe that our arrangements should be changed at all.
All right. Thank you. There must be a showing of either proper cause or change in circumstance. Court finds a change in circumstance. The defendant was arrested in this matter, or not in this matter. She was arrested relative to criminal allegations of controlled substances. The information provided by father, which is uncontroverted at this time, uncontroverted, indicates that the child was in the vehicle. On an interim basis, the court is going to order that Mr. Apley shall have sole legal, sole physical custody of the minor child. While the defendant is incarcerated, any parenting time is suspended. Once, if she is released from the county jail, she can file a motion to address parenting time. This is an interim order, and so it's not a permanent order. And the court will also order that with having interim sole legal, sole physical, the child cannot be removed from the state without prior approval of the court, nor more than 100 miles from the child's current address. Anything else, Michelle?
Is the court also ordering that child support be abated effective February 23rd, 2024?
Yes. And
I can't hear anything you guys are saying.
Oh, the support is going to be abated. There will be no support that'll be owing from you at this point as you are currently incarcerated. And the court is also going to order a friend of the court investigation regarding custody, parenting time, and support.
Okay.
Is the court ordering an investigation prior to release, or how does the court wish us to address that?
I just wanted to start now. Just to start it now, so we don't delay things. Because eventually the criminal charges will be moving forward wherever they're going. I don't know where they're going, we'll find out. Do you have anything else?
Just to clarify, currently, Mr. Apley is the payer of child support. So it is his obligation that's being abated, held,
Oh, I'm sorry.
stopped. But we will address support in accordance with the custody and parenting.
Yes, thank you. Appreciate it. You're all set, folks. Thank you.